Roll call, please.
John Wiener. Murdig,
Here.
Ellefson,
Here.
McKenzie,
Here.
Negro. Metzinger,
Here.
Campbell,
Here.
Ray,
Here.
Kinney,
Here.
Hufall,
Here.
Frantic,
Here.
Stark,
Here.
Stendor,
Here.
Berlin,
Here.
Miranda,
Here.
Mika,
Here.
Vitek,
Here.
Huber,
Here.
Shooty,
Here.
Carl.
Here.
20 present, 1 absent.
This is
Oh,
Laura Negro.
You say.
Here.
This is Laura Negro. I'm here too.
Next thing on the agenda will be a moment of silence, and then we'll do the pledge of allegiance. Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next is a approval and adoption of the agenda. We need a motion. Gary,
Also move. Murdick.
I'll second that motion.
motion by Gary Murdy, seconded by Kathy Shooty. All those in favor say aye.
Aye.
Anyone opposed? Motion carries. Thank you. The hearing will be conducted by Mr. Alex Morbacher. Is that right? I don't have a card.
Can I ask a question?
Okay, can you hear me?
Yes.
Just leave it on like that. Okay, thank you, Chairman. My name is Alex Morbacher. I'm an Assistant Corporation Counsel for Ashland County. I'm helping with the meeting today. We're here today to review on an appeal of the impartial decision made by John Carlson that was signed on April 17th, 2023. In the employee handbook, under section 1.05, subsection C, there are some rules for how we're supposed to conduct this meeting. The decision that John Carlson made on April 17th, 2023, the written decision has been provided, as well as the exhibits. The purpose of today is to review that decision and everything that he had to go with the decision, including the examinations of witnesses, the exhibits that he had a chance to review, and the arguments made. Under that subsection C of 1.05 in the handbook, it says that the county board shall not take testimony, accept additional evidence, accept briefing, accept oral argument, or otherwise conduct a hearing of any sort in relation to an appeal. What that means is we're not to consider anything more today than what John Carlson had to consider when he conducted the hearing as the impartial officer. Some of you might have seen video of the hearing that was available online beforehand. It's also been provided. And if you'd like to see the video today, you have every right to do so. You have every right to look at anything that was considered when the decision was made. And that's the purpose of today. And so if folks want to see exhibits or watch more parts of the film or certain parts of the recording of the hearing, that's what we're here today to do. we're not to consider additional arguments. And so if there's been other things said about the hearing afterwards, those aren't to be considered as a basis for the decision today. The standard of review, according to the handbook, is the board, and I'm reading from section D, the board may overturn or otherwise modify the impartial hearing officer's decision if the decision of the impartial hearing officer is found to be clearly erroneous. Clearly erroneous is not defined in the handbook, but I think you could interpret it by just reading the words literally on it. It's more than just erroneous. It has to be clearly erroneous. There are some cases on civil law that define what clearly erroneous is. I'm not sure if they're helpful or not. I'd offer that one common description of the standard clearly erroneous is it is clearly erroneous when it is against the great weight and clear preponderance of the evidence. After everyone's satisfied that they've had a chance to review everything that was reviewed by the impartial hearing officer, and there's no other questions or discussions, then there has to be a decision as to whether or not the hearing officer's decision was clearly erroneous based on what he had to consider. As a result of this decision today, the board has to provide a written decision. And I'm reading from section E of the handbook. That decision has to be provided no later than 10 days, 10 calendar days, I should say, from the date of the meeting today. The written decision shall contain a statement of the issues, findings of fact, along with an explanation as to why the findings differ, if at all, from the impartial hearing officer's findings. Conclusions of law. And if conclusions of law are different for the board than the impartial hearing officers, then there needs to be as well an explanation as to why those conclusions differ. And if they do differ and a remedy is warranted under section F, then what that remedy is, along with an explanation as to why the remedy differs from the remedy granted by the impartial hearing officer. Does anyone have any questions? Like to begin the session? Okay. I'll get it on the record here. Ms. Lavasser has the right to have this be held in open session the entire time. That is provided by statute. Prior to this meeting, Ms. Lavasser has requested that the entirety of the meeting be held in open session. She just restated that that is still the case. That hasn't changed. And so the meeting today will remain in open session throughout the entirety of it. Has everyone had a chance to review the documents provided either now prior to the hearing? There's been video. Some of you may have seen the video already. Upon reviewing the video, it doesn't appear that it was edited or changed. And so other than maybe an intro ahead of time that can't be considered today, the video seems to be accurately portraying the hearing as it was held. So does anybody wish to have additional documents? You've been provided packets on your desk. In the packets, there's a few things that were referenced on there as being large documents. And so maybe the first thing we can do today is determine if anybody would like copies or excerpts of those larger documents that aren't directly in your packets. Yes, Mr. Kinney.
Want to ask, in the conclusion from the impartial hearing officer, part of it, at the very end of it, he indicates that a termination date of January 30th was considered. How do you want us to handle that discussion and decision versus the other part of this?
I think that should be considered as a separate issue today, what the termination date is. And so the issue is, what was the termination date? Findings that might support that. Some of the findings might be when the letters were sent out, what was the contents of the letters, and do we agree with the impartial hearing officer that the official termination date was January 30th, 2023, and not prior to that? So that should be a separate issue that has its own findings and conclusions. And if they're the same as the impartial hearing officers, we should make that clear in the final decision. Good question. One item in your packets is a police report that's rather lengthy and has some sensitive information in it, but that is available to you, to every one of you, if you'd like a copy of it. And so if anyone wants a copy of it, please let me know, and we'll make sure that you get a copy. If any, oh,
I would like a
Shoot.
copy of that, please.
okay, anyone else?
I would also. One more thing, Alex, if you could speak up a little bit louder or closer to the mic, I think that would help some of us.
My apologies, I'll do that.
Thank
Oh,
you.
I hear that it's louder already.
Thank you.
Thanks.
Excuse me, I don't mean to interrupt. My question though is this, what is this packet? Is this available to the public? What is this document that you're referencing?
Document being handed or passed around is one of the exhibits provided at the hearing. It was exhibit 14 at the hearing.
Okay, but the packet itself, does that contain all the exhibits or something else?
The packet contains all of the exhibits or excerpts of the exhibits.
And I'm sorry, did you answer the question as to if the packet was available to the public?
No, it's not.
After the sheriff yesterday and asked reinstated in a different position. Is that something that should be mentioned now? No.
Excuse me, if people aren't talking, can you use the mics, please?
I use the mic.
My attorney would like a copy of everything that was given to them to make sure that it also wasn't amended.
Okay. Thank you.
And Alex, I'm sorry. You said during your speech here that everything was provided to everyone prior. So you're saying that all video has been provided to them, every single member?
My understanding from talking with you before the meeting was that it was by request before the meeting, but it is available now.
So you're saying that they don't have to watch it, but even though that's part of the job to make sure if anything was correct or incorrect. So that wasn't given to them then?
If anyone wants to see the video today, the video is available and we can take as long as we want to go through this. And so I don't
I'm
think,
just saying that because you said in your statement that if everything was provided to these guys, but it wasn't. So just, I want that on record that the video was not
but
provided to.
and I'm just going off of what you told me before the meeting, but it sounds like it was by request prior to the meeting or by going online and watching it online.
This is Supervisor Franek. I did make it a request to watch the video in the courtroom. That day I was not feeling good. Before that, I had found out it was online. I watched it online, so I told them I wouldn't be able to make it into the courthouse. They told me, they advised me not to watch the online version and to come in to watch it it was up to me though, but I had already watched it.
Yeah, the preference would be to watch the version provided from the hearing, but we've seen the one online. Other than the editorial at the beginning, it seems like it's fairly undoctored. So would anyone else care to watch video today? I understand that we're reviewing and I don't want to rush anyone. We have lots of time. Mr. Kinney.
I'm reading from the independent hearing officer's document, and I'm looking at page 7, and in about the middle of that, it says, although the county must only show that there is at least one rational basis for termination set forth in the county's denial of the grievance, this decision will review all the reasons asserted by the county. So my question is this: if the county only needs to show one reason, what obligation does the board have to consider all of the evidence that was gathered and presented, including what was shared with us in this police report?
No obligation beyond to the extent of what you want to do today. You're allowed to look at other issues, but there's only a need to have one rational basis for the decision as required in the handbook. So we don't need to go through each and every one if we don't want to. You don't have to go through the defenses if you want to, but we certainly can today. And if people have questions or want to have discussion about some of the defenses that were raised, this is a great time to do that.
I have a question. Is the January 30th date that keeps coming up in this discussions, is that a separate question for the board to answer? Or can the board answer that question before any other decision? Could we agree on the 30th of January being the date of termination?
The answer is yes. We can, and I think we probably should for clarity, just address that issue separately. So you could have the issue being, what was the date of termination? Do we agree with the findings that the impartial hearing officer had? Some of those are that the January 19th letter did not provide a notice of termination. Another finding in there might be that Zupke did not terminate on January 19th. And then yet another one might be Attorney Lindsay's letter dated January 27th clearly indicates that employment was terminated, but that wasn't provided until the 30th. So the conclusion of law in the impartial hearing officer's decision was that the termination date is January 30th. And I think the board should rule on that one way or the other as to whether they agree with that or not.
Then if this is the proper way to handle that, because that is an issue sticking out there, I would make a motion to acknowledge that the date of termination was January 30th of 2023.
Ray will second.
Who seconded it? Right.
We do a voice vote, probably, yeah. And then as part of the vote, are you going to offer some findings and whether there's any disagreement with the findings and impartial hearing officers report? Mr. Kinney?
I would suggest a roll call because this means that we're actually spending funds to extend the compensation, and to be on the safe side, I would prefer the roll call.
No objection to that.
Kathy.
Could we have a discussion before we take the vote as to what's the difference between the two dates? Why is there a decision that we're not clarified on that?
Yes.
Thank you.
Point of order, is there a second on this motion?
There's a second, but I would like a discussion before we vote, so it's clear with everybody why there's a difference in the date.
Okay. Mr. Bussey?
Okay, as those of us speaking to termination, I'm mostly here to listen and to review.
Can't hear you, Judge.
I said I'm mostly here to listen, but I want it to be known on the record that my preliminary conclusion after reading through all the material in detail is that I find this termination irrational and grievous. It's very abrupt. It's a termination of a 20-year employee with a good record for no rational cause of the abruptness of the termination. I can understand the discretion of the sheriff in terms of assignment, but I do not understand see any rational reason for this abrupt termination. Thank you.
Thank you.
We have a motion and a second on the table to vote on this date. Pardon?
There was a request for a discussion.
Yes.
I know.
Mr. Metzinger?
They said.
Why are we having this discussion if the vote is overturned? Shouldn't we decide that first and then decide the date of termination if that's the case? Because we do not know if it's going to be upheld or not.
Thank you. Ms. Shudi?
The question is there seems to be a conflict of two different dates of the determination letter, termination. So before we vote on it, it would be nice to know what's wrong with the two dates. Where's there an error? Let's clear the error, the ERROR, before we vote on it. If somebody could do that.
Mike,
If we were to vote on, say, we were to vote yes on January 30th being the termination date, what if we don't think there should be a termination date at all? Would we vote no on that, that question? I mean, the motion that's in front of us is changing the date to January 30th. Correct? That's the motion that was seconded. So would a yes vote, would a no vote mean? What if you don't think it should be termination at all, you'd have to vote no, right? You wouldn't vote yes as a termination date.
So if I understand the concern, there's some members that are feeling there's no termination at all. And the concern is having a vote on what date the termination is eliminates the issue of whether there was termination at all. Okay. Mr. Campbell?
As I read the conclusion of the hearing examiners, he says that her termination date should be considered January 30th. And the county should ensure that all wages and benefits are paid to Ms. Lavasser through January 30th. So that's, he's already, his determination is that the date is January 30th. So I don't know why we need to vote on that when that's, in his conclusion already.
So
right.
when the impartial hearing officer had this hearing, it wasn't whether termination happened or not. The question was, and I'm going to go back to it exactly here in the employee handbook. John Carlson, the impartial hearing officer, was charged with determining if Ms. Lavasser, persuaded by a clean and convincing and satisfactory evidence that the county's decision to discipline/terminate the employee did not have a rational basis. So to the extent that whether termination happened or not, I'm not sure if that was an issue that the impartial hearing officer was addressing, but the board here today has the opportunity to review everything there and reach its own decisions based on the same things that the impartial hearing officer had.
Alex?
Yes.
So just to get back to the question, so there's another date that they say could be the possible termination date. Does everybody agree on the 30th then that we don't even need to vote?
No,
Why are there two different dates?
well, when you read the analysis in the impartial hearing officer's decision, he notes that it's not clear. And I think there was argument made during the hearing as to whether it was one day or another. And so when I read the decision, it says, the issue of I'm reading from page 5 section A, first under the analysis, the impartial hearing officer's conclusion here was that the issue of termination date was not critical in determining if there was a rational basis or not. So that gives you some insight as to where his mind was at on this issue. But he decided to make a conclusion anyway, based on the content of those letters, which is provided to everyone in their packets. You can read the letters yourselves and decide if you agree with this, with his conclusion as to whether the termination date was January 19, January 27, January 30th. But that's on the board today to go through, look at the same things that Mr. Carlson looked through and determine if they have the same findings of fact, the same conclusions of law, and if any remedies are required, those as well.
Thank you. Did both parties agree to January 30th?
During the hearing,
Was there anybody that was against it?
I'm not aware of that myself, no. But that's something that we could look into today. We have the record in front of us. This is our time to do that.
So nobody said that they were against January 30th. Everybody agreed in the room.
I can't say that for sure. We'd have to look at the video. Mr. Carl.
So basically, we're here to decide whether the sheriff made a mistake, the county administrator made a mistake second, and then John Carlson made a mistake third. That's what we're here to decide.
We are here today solely to review Mr. Carlson's decision. We're going to look at everything that Mr. Carlson looked at, and we're going to decide if we agree with his findings and conclusions, or if we disagree with his findings and conclusions based on the same materials that he had to consider.
So just Mr. Carlson's decision,
Just Mr. Carlson.
which the evidence he reviewed was the administrators and the sheriff's decision. He reviewed those to make his decision.
Which are exhibits that are
Right,
provided, yes.
correct.
Yes,
Okay.
yep. Ms. Granick.
I have a lot of comments. You can forgive me if I jumble on too much. If we do or do not agree with the dates or whatever, but first and foremost, I agree with George. I believe that this is irrational, that somebody with so many years of experience during COVID and getting her job under extenuating circumstances was not allowed to come up, or not come up, but to correct her so-called errors in her job. And if we believe that she was terminated on the 19th, as I believe, if you are called in, okay, just as an individual, if you are called into your boss's office and you're having all these issues of understaffed, overworked, you're tired, you're listening to everybody's complaints and everything, you're answering the phones, as a previous inmate's daughter or mother, just to call the jail, it takes a while to get through to a person because they are understaffed, because of trying to watch all the inmates. And so many inmates now are coming in with extensive mental health issues, extensive drug abuse patterns. And, it's like watching 12 toddlers times 2 or 3, or how many inmates they have. And when you're called into your boss's office and they give you no reason, you're flabbergasted at first. And then you're wondering, what are my options? And first you're in shock. You cannot answer anybody. And it's how somebody, process this pattern of, it's grief, because you feel like you've got the rug ripped underneath you. And anger, it's every emotion in the book. And for her to leave that day and not say anything was shock, was grief. She was processing. They didn't even give her a chance to say anything back. So that's how I believe. Thank you.
Thank you.
Call on the question. Of the date. Okay, because it's still on the floor.
Do-
I don't know why it's even on the floor. Because I made a motion.
Already determined.
No, not.
So if you Oh.
want to take a vote for the move. Like need a bell.
Yeah, I just raised my hand. Sitting next to me that talks too much.
So we should take a vote. Pat wants to vote.
All right, we're going to take a roll call vote.
Okay,
have a question.
Do we have to vote on this motion before we go any further or?
Is there any other discussion on the date being January 30th? Yes, Mr. Bussey?
I'd like to move to table the motion.
I'm sorry, one more time?
I'd like to move to table the motion.
I'll second that. Mike Stark.
Vote now is the motion to table.
And the date?
Okay, so just as a point of procedure, the original motion on the table was to agree that the date is January 30th. There is now a motion on the table to table that motion. So how we would do this is we'll take a vote on the motion to table. If that succeeds, then the underlying motion is gone. If it fails, then you take a vote on the underlying motion. Take it on, right now you're voting on the table. The table Gary's motion.
We're going to do a roll call on it? Okay, Lori, do you understand what we're doing here? Take a roll call vote on changing the date.
Okay, okay, so a clarification, what exactly you're voting on? So, all right, so this is on a motion to table Mr. Mertig's motion that establishes the date of January 30th. So a yes vote means you're voting to table Mr. Mertig's motion. A no vote means you're not voting to table it. And you would like to take a vote on the underlying motion.
I'm just gonna make a statement. The vote goes however it goes, but I don't understand the whole question here because we're just voting on what date is the actual termination date. We're not voting on termination. We're just agreeing that in this letter from John Carlson, it says January 30th. We've had multiple dates and that was the question. So thank you.
Okay, Lori, once again, we'll have a roll call vote on the date, changing the date.
We're gonna have a roll call vote on the motion to table.
Oh, Christ.
Murdig,
No.
Ellefson,
No.
McKenzie,
Abstain.
Negro,
No.
Metzinger,
Yes.
Campbell,
No.
Ray,
No.
Kinney,
No.
Hufall,
Yes.
Frantic,
Yes.
Stark,
Yes.
Stendor,
Yes.
Berlin,
Yes.
Miranda,
Yes.
Busse,
Yes.
Mika,
Yes.
Vitek,
No.
Huber,
Yes.
Shooty. Yes. Carl,
No.
Weiner. Twelve yes, 8 no. Pass.
So the motion is tabled and the floor is empty or open.
Ray will make a motion to accept the hearing officer's impartial decision as complete. So that the burden of proof was not met and date of January 30th is termination date.
This is Kenny, I'll second.
What's he seconding?
To accept the hearing officer's decision.
Who made the most?
Right.
Oh, okay. So we gotta vote on that now. Pardon? Mike. Go ahead, Mike.
Okay, so there's discussion, vote, if we vote yes on this, it means the meeting's over, we accept the termination and it's all done. If you vote no, does that mean that we've overturned it?
Yes, that's exactly what that would
Okay,
mean.
so yes would mean that we've accepted the decision of Carlson and no would mean that we don't accept it. That's what this motion and second is, right?
Yes, that's correct.
Okay, thank you.
That's just determining the date, right?
No. All right, so to be clear, Mr. Ray's motion is to accept the impartial hearing officer's decision in full, including the January 30th termination date, that there was cause to terminate. No vote. A yes, so a yes vote means you accept the hearing officer's decision. A no vote means you don't. If there's a yes vote, it's over. If there's a no vote, then you have to come up with remedies afterwards.
To fulfill the requirement for the written decision, we should probably add that we're agreeing with the impartial hearing officer's findings and conclusions too, just for clarity.
Yeah. And Mr. Ray, is that correct?
That is perfect.
Clarence.
One of the concerns I had in looking over all this information is the appeal form that was appealing this decision to the county board. In the preface states, Ms. Lavasser contends it is impossible for the hearing officer to be impartial on information and belief the hearing
Mr.
officer,
Campbell,
John.
That's new evidence and cannot be considered by the board.
Okay.
It wasn't
mean-
presented at the hearing, so the board cannot consider that.
Okay, and that's what, okay. And that was my concern is that, you know, there's nothing that has been shown that was influenced the decision.
George.
Yeah, I elaborate on my position that the hearing officer is in egregious error.
You
There's-
speak up just a little
There's,
bit. We can't
there's
hardly hear.
nothing that I find in the documentation that points to rational reason for termination. I understand that you have to support the prerogatives of the sheriff regarding to assignments, but I don't see any evidence of a need for termination of a 20-year officer, and I find it irrational.
Yes, Liz.
I again agree with George, and the way that it was just done was just, like I said, you know, she was terminated that day with no rebuttal at all. I mean, like, you either take this job or you don't have a job, you know, and there was no, we're gonna address, you know, to you to fix these things that are wrong. And you have so many days to decide if you want to be this other job. Otherwise, we're gonna have to let you go. There was nothing in the evidence in anybody's testimony that would lead to that decision that she would be terminated immediately or given this other job. And if she was such a potential danger to the job, why would they offer her a demoted position?
And I'd encourage any opponents to the decision to focus on the specific findings that he made. And whether or not you agree with those specific findings or not, both either direction. And the conclusions and so forth, Mr. Stark.
Just as a comment, I'm going to agree with what George said. One of the things that's bothered me is it's never came before the law enforcement committee of the county at all. Prior to any of these hearings. Never came through the law enforcement committee. That's just a comment.
Mr. Ray.
So under Wisconsin law, employment is an at rule or is at will is a rule. So there are no protections. There are no length of time or hardships on the job. Wisconsin is an at will employee. That means that if it's made, the decision's made, the grievance officer did not make any egregious error following state law. State law is there. We cannot go against the hearing officer's case because there is no error when employment is at will.
Kathy?
I believe the county makes a big mistake when they do that because you have good employees and somebody doesn't like you for whatever reason and you're gone. I think the county made a big mistake when they went that way. It's my opinion. Thank you.
Brad?
I agree completely. That's state law. We have no choice over it. We can't change that. If we want to change that, we need to lobby downtown Madison and get that changed. But as it stands, there are no protections for any county employee.
George?
The way I see it, and I'm not fully attuned in the law, but the fact that the county can dismiss somebody at will doesn't make it a rational decision, and it can in fact be an egregious decision. And therefore, I believe the arbitrator reached an incorrect conclusion because the facts do not support termination.
Ron?
Can we vote? Call the question.
Okay, a question's been called. There's no further debate. You now will be voting on calling the question. If you vote yes, that means you're voting to end debate. If you vote no, that means you're continuing to debate. Following this vote, if it's a yes, there's no more debate. You move directly to the original motion, Mr. Ray's motion to accept the findings. And a roll call vote should be requested.
Lori? Go ahead, Lori. We'll have a roll call vote, please. On any debate.
Is there anybody that seconds calling the question?
This is Laura. I'll second that.
Okay,
Can I ask what the vote is clearly now, what we do, like? yes or
you're
no?
voting on calling the question.
Okay, so
Calling the question, ending debate.
Any debate? Yeah.
Ellison,
Yes.
McKenzie,
Abstain.
Negro. Yes. Metzinger,
No.
Campbell,
Yes.
Ray,
Yes.
Kinney,
Yes.
Hufall,
Yes.
Frantic,
No.
Stark,
No.
Stendor,
Yes.
Berlin,
Yes.
Miranda,
No.
Busse,
Abstain.
Mika,
No.
Vitek,
Yes.
Huber,
yes,
Shutey. Carl,
Yes.
Weiner,
Yes.
Murdig,
Yes.
$13 yes, 6 no, 2 abstain. Calling the question.
Okay, the question has been called. So under the rules, there's no more debate. So the vote now is on the underlying question to accept the hearing officer's decision and in full. A yes vote means you accept the hearing officer's decision. A no vote means you don't. And is a roll call requested? Yeah, okay, roll call has been requested.
McKenzie,
Abstain.
Negro,
Yes.
Metzinger,
No.
Campbell,
Yes.
Ray,
Yes.
Kinney,
Yes.
Hufall,
Yes.
Brannick,
I want to be clear, what does the yes mean and what does the no mean?
A yes means that you accept the hearing officer's decision in full. A no vote means you don't.
No.
Stark,
No.
Stendor,
No.
Berlin,
No.
Miranda,
No.
Busse,
No.
Mika,
No.
Vitek,
Yes.
Hubert,
No.
Shooty,
No.
Carl,
Yes.
Weiner, Murdig,
Yes.
Ellefson,
Yes.
the tie.
The vote is a tie. That means no decision has been made, and debate can continue.
Metzinger?
If we're continuing discussion, I read the pamphlet twice. And I found it hard to determine, was Ms. Lavasser salary employee or was she an hourly employee? As
Would
far
that-
as being the head jailer.
She's an hourly employee.
I thought going through the tapes that it was mentioned that she was a salaried employee.
If that's what it's evidence says, and that's correct, and I made a mistake.
Mike.
A procedural question, if the vote was tied, don't you have to have a majority for it to be approved?
No.
No? I don't know what
I think it just means it failed.
it failed.
It basically failed.
It failed if you don't, if it's the tie vote, it didn't pass.
It didn't pass.
It didn't pass.
Yeah.
So it's done.
We're done.
Yeah.
It didn't pass.
It didn't pass.
Right, yeah, Mr. Stark is correct. The vote fails if it's tied. Mr. Stark is correct. A tie vote is considered failed. That's. So, well, we're not done because you still have to decide on, is there a remedy to provide? It was 10 to 1, so a tie vote fails. I'm sorry. Okay, Alex, can you please explain this to the board?
My understanding was the vote was to accept it in full, and so that has failed, and we're back to discussion at this point.
I think he's saying that in order for Ms. Lavasser to prevail, you still have to have you have to make a motion to say that you agree with, you agree with her position.
And if there's disagreement, we need to have the specific findings that we disagree with. That needs to be included. There has to be the specific conclusions. There has to be a written decision that includes what we specifically disagree with, what conclusions we disagree with, and so forth.
What was the final vote?
10-1.
Okay, thank you.
Ms. Miranda had a question.
Go ahead, Laura.
So my concern is that you typically, when you terminate an employee, although that there were some rule violations, there was no corrective action, and being employed, holding the position from May 2021 to January 2023. And there was no corrective action or anything to support like they tried to help her be more
Efficient.
efficient and have leadership qualities. They just, and spring it upon you like, oh, here we are. So that was my concern.
Is there a part of the impartial hearing officer's report that
Well, they
you could
don't
direct that
offer
to?
any corrective action or like you also have a employee evaluation.
Just review and just offering this for continued discussion and just in the efforts to get us to a written decision that has the requirements that we need to have. Some findings that might be noted in the impartial hearing officer's decision on the very important issue of, did the county's decision to terminate have a rational basis? That was what his task was. That's what he had to determine in the end. Was there a rational basis, Some of the things that he cited in his decision included Ms. Lavasser's termination was the series of alleged sexual assaults that occurred in the jail in September of 2022. That was a finding, a fact that he made on there. Or a conclusion rather. Another finding of fact was that a correctional officer tendered a statement of resignation citing a lack of control from jail administration. Another finding was that an investigation was completed regarding an inmate claiming that another inmate sexually assaulted him while Ms. Lavasser was jail administrator. Another finding of fact would have been items were hung to block the view and inmates went into other inmates' cells during Ms. Lavasser's time. These are findings that the impartial hearing officer made after reviewing the exhibits, and that includes that police report, amongst other things. The impartial hearing officer had a finding that an inmate sexually assaulted another inmate during Ms. Lavasser's tenure. There are numerous rule violations in the exhibits provided that the impartial hearing officer included in his decision, including section 9.1, inmates will not enter another inmate's sleeping area unless authorized by jail staff. Section 9.1.7, prohibiting inmates from entering another inmate's cell or any other use, or any use of a bunk not assigned to you. Also prohibiting inmates from obstructing in any way a clear view into any cell or living quarters. This includes hanging items from doors and or bunks. Section 9.25, general rules. Prohibitive acts include entering unassigned cell and blocks cells of view. Section 9.2.1, requiring inmates to be provided a written statement of the violation for any infraction of jail rules. Section 9.2.2, requiring the issuance of a disciplinary action report for any major infractions of jail rules. He had a finding that Ms. Lavasser did not dispute Detective Pierce's report. That could be reviewed upon the board today in determining, looking at the same thing. Do we have the same finding as he did or not? Ms. Lavasser did not believe the Ashland County Jail rules and regulations applied. That was a finding he made based on what he saw that we should think about today in terms of do we agree with or not, based on what he saw as well, not other things, not things that we've heard in the newspaper, not arguments that we've heard otherwise, solely on what he saw. We're looking at the impartial hearing officer and deciding, did he do his job correctly or not based on what he was provided? If we enter new information in, that's not fair to the decision because he didn't have the benefit of that information when he made his decision. So we're reviewing the impartial hearing officer's work here is a way to think about it. His conclusion was that there was a rational basis to terminate.
Mr. Chair, the vote has already been taken, so I don't understand why we're hearing a repetition of everything we've already read.
You still have to come up with a finding of fact then. And are there remedies available? Alex, can you continue and explain what they have to do still?
So I'll go back to the beginning here. The county board under section 1.05E has to deliver a written decision to the employee and the county no later than 10 days from the date of the county board meeting, the written decision shall contain 1, a statement of the issues, 2, findings of fact, along with an explanation as to why the findings differ from the impartial hearing officer, 3, conclusions of law, along with an explanation as to why the conclusions differ from the impartial hearing officers, and 4, a remedy, along with an explanation as to why the remedy differs from the remedy granted by the impartial hearing officer. There is a section on remedies, and I can go through that quickly as well, so we can think about what types of remedies are on. The county board may award the following remedies to the employee on appeal in a matter of involving discipline or termination: A, reinstatement; B, a lesser adverse employment action consisting of suspension, reduction in the length of a suspension, written reprimand, or documentation of employee acts and or omissions in an employment file; C, back pay; and D, in the event of a reinstatement following termination, reimbursement of the county's applicable percentage of any payments made by the employee for continuation of health insurance under the Consolidated Omnibus Budget Reconciliation Act, COBRA.
Well, we gotta pass this around a little bit, Mike.
So could we make a finding or a motion that would say something like, it suggests that she has a personnel evaluation, a plan put in place on how to remedy any shortcomings, and what would have to happen in order to be put back into the job? I mean, it'd be like an evaluation, and who would do that? Would it go to the law enforcement committee first? And then, but that would be a remedy. A remedy would be a performance evaluation with a plan on how to improve shortcomings.
As a statement of fact, the Public Property and Law Enforcement Committee is a policy committee. It does not handle any administrative work. And any kind of performance evaluation for an employee in the sheriff's department is the responsibility of the elected sheriff, not anybody in this body.
Yeah, I mean, that answers the question, but I mean, we can direct that happen as a solution or the remedy to our findings, correct?
No, you cannot direct the sheriff to do anything. The sheriff is an elected official, constitutional official unto his own, and he can perform his job in any way he sees fit.
Quick question.
Kathy?
Laura, if you could help me, had this issue or question about this county employee ever come before the Public Property and Law Enforcement Committee?
Again, to reiterate what Dan said, our committee does not do human resources, hiring, firing, et
Okay.
cetera. So
You didn't know anything about this?
not all the details, but
Yeah.
that there was something going on.
Okay.
So
To vote on whether this arbitrator did his job right, the facts he had.
Clarence?
I'm not an attorney. I'm not trained in labor law or labor relations. And I have sympathy for Ms. Lavasser. I think we all have sympathy for what happened. But I think we need to look at what took place during this grievance procedure and during this hearing. And like my colleague to my left, Mr. Ray, under Wisconsin law, employment is at will. At will is the rule. That means that an employee, as it states down below there, the county employment relations with employees eligible to use this procedure is at will, and employment may be terminated at any time for any reason, with or without cause, with or without notice, at the option of the county or the employee. We cannot like how it happened. But the hearing examiner is saying the county had the ability to do that. And he ruled that way, and we might not agree with it, but he went by state law.
George.
This is a rebuttal to Supervisor Campbell's position there is that this board represents the county and the county can determine its position by vote of this board.
Great.
Yeah, and the confusion comes in, our real reason for being here today is, did the hearing officer make a grievous error in law? And if you read this entire document, you're voting on whether or not he made a grievous error in law. It's not about personalities or who we like or dislike. It's about this piece of document, and that's what we're voting on or did vote on.
Well, and I'll read the standard of review again. The board may overturn or otherwise modify the impartial hearing officer's decision if the decision of the impartial hearing officer is found to be clearly erroneous. And I don't think we have that yet. I think there'd have to be a motion that it is clearly erroneous with the specific findings that this board finds to be different and the specific conclusions of law that this board finds to be different, because we need to articulate that in the final written decision.
Laura.
And I understand that the procedure that was done wasn't done exactly like some of us might do, but firing someone is actually a remedy for not doing your job. It's the shortest path. And we may have wanted to see other ones, but because of the law, that's what can happen. And that was one of the ways to remedy this situation that was in the box of tools that was in front of Dan and our sheriff. And just because we didn't like which tool they picked didn't make it wrong. Because as we sit here too, we are representing the county and the county's interests also. So we have to think about this because it was one of the tools. It's not the happiest tool, not the best tool, but it was one of those tools. And that's what the hearing officer said is, yep, they used one of the tools that was there and they had the right to do that.
Pat. I read everything that was sent to me, and the question I asked myself, how in the world, as a county board, we're responsible for the county, the residents here, we're fiscally responsible for the county too, which means in part, we minimize the risk of getting sued. We have videotape in that jail, and if you recall a few years back, before I was on the board, something happened in the jail, so they added more cameras, so there's not blind spots. That means that what was documented with video evidence. This isn't an isolated incident that happened once and then was addressed. Things happen in the jail, and as long as they're addressed properly, that's understandable. But there's evidence that shows a repeated pattern of behavior. You read through the police report and what happened, you have somebody being sexually assaulted in there on more than one occasion. We have an obligation to that person. We have an obligation to others that are going to be in that jail. This person was offered the opportunity to go back as a correction officer, and I hope that if this hearing officer's decision is upheld, that the county does work to rehire this person as a correction officer after going through some things in retraining. One of the things that concerns me, I mean, this person does not seem to be a good fit. Part of it is, as the hearing officer says, a lack of responsibility. This person spent 20 years as a correction officer, knows the rules. They read them to the inmates all the time. It's a 3-page summary. To say we don't use this 67-page manual that's supposed to be reviewed annually, and you're in charge and you're not taking responsibility and you've got sexual assaults going on, how in the world do we justify continuing the course that we've been down? We need to change course. There are things we need to do better as a county, no question about that. But continuing what we're doing, I cannot for the life of me understand that. when you have people sexually assaulted in our jail under our watch, that to me is first and foremost versus did the county, cross the Ts and dot the Is? The real question I have is, why did it take so long for the termination to occur? Because this incident was known far earlier. We're actually late on doing this, and the person was given an opportunity to come back as a correction officer. And I hope that still works after, some training and review and working through some issues. But the preponderance of the evidence, as the attorney here said, the preponderance of evidence does support the independent hearing officer's decision. I don't see where he made an erroneous mistake. And going back on page 7 of his summary, that there's at least one rational basis. I think having people sexually assaulted in our jail is a rational basis to support his decision.
Go ahead, Liz.
I'm not, a law enforcement officer. I am not a lawyer. I am not a state official. I'm a county board representative. And I've seen all the videos. I've seen all the evidence. And I heard, I think it was Sergeant Wilbur and another officer, I'm not sure. Somebody had said that there are still blind spots in the jail. And with watching how many inmates, and if somebody is busy booking people in, these criminals are smarter than any of us sitting here. They have nothing but time to think and watch that officer, and we have to be smarter than them. And yes, there needs to be more training. Yes, there needs to be more things done. And we do have a responsibility to these poor victims that have to go through abuse, sexual harassment, and assault. But we need to look at all the facts, and in the findings, it does not say about, why nothing was, yes, why nothing was done, but this person did not come up to, write this letter until it already had happened. And they're the blind spots, and about concealing things and hanging things. Sergeant Wilbur did say that they're allowed to hang towels to dry. These people are smart, and if they want to be abusive to somebody else, they're going to act so nice when that sergeant or officer is there. And we have to train our officers, our lieutenants, our sergeants, everybody to work together to identify these sort of people that are going to offend. And that's when I look at the facts, I look at, yes, these things did occur, but some of these things are not an officer's fault. And like they said, there was no leadership or professionalism. I don't agree with that either. Thank you.
Go ahead, George.
Oh, okay. So there seems to be a two-part problem here. One is whether or not the officer ought to retain the role as supervisor of the jail. And secondly, whether the officer ought to remain on the force in employment of the county. And I would sustain the sheriff in the sheriff's decision to remove this officer from the role as supervisor of the jail. It seems to me within the sheriff's discretion. But, I come from a world of the corporate world, so maybe I don't understand the rules exactly. But it seems to me that our recommendation to the sheriff might be that this individual be offered continuation as a corrections officer for a probationary period of 6 months and have a chance to get things back on the rails. And that would be a solution. But I think we've already voted that we do not sustain the arbitration hearing officer's conclusion. So now we're looking at what our recommendation should be. And that's kind of where my mind sits. I think this person deserves the right to continue on the force as a corrections officer be offered a 6-month probationary period. And should this person decide to resign, but I don't think there was adequate time given for the officer to consider whether or not they would continue it as a corrections officer and not be supervisor of the jail.
So I just want to reiterate that I think there needs to be a vote today that the impartial hearing officer's decision is clearly erroneous. It's not enough to say that we don't agree with everything in there. But that's not the same as a finding that specifically it's clearly erroneous and why it's clearly erroneous. So I don't think the vote that we had is enough to say this is over and we're moving on to remedies. It has to be specifically that there's clearly erroneous.
We were told at the beginning of that vote that that was it, that would make the decision, that would be determining that it was clearly erroneous. And I believe that in the essence of that motion was that if we voted not to sustain the hearing officer, that
Right,
was the
so
end of the
that-
question.
So now you have to vote on that the vote was clearly erroneous and why. Because there has to be a statement of fact of why that decision was erroneous.
No adequate time.
And once you have the findings that are different and the conclusions that are different, I think that helps us think about the remedy, because now we know why it's wrong. And then we can tailor the remedy appropriately according to that.
Okay, so I guess I'll propose a motion that the hearing officer was clearly in error and that his conclusion was erroneous because of the abruptness of the firing without due consideration to the employee.
Thank you.
Need a second on that.
I'll second that motion.
Bill, under discussion, the individual that worked for Ashland County that was a jailer on duty, when they noticed these violations, was it not their responsibility to go ahead and stop something? And say, hey, you know, this is happening, let's stop it right now. And why did that not happen? And if it didn't happen, was the person on duty, were they reprimanded? And it doesn't appear that they were reprimanded. And then all of a sudden, they're saying it's the head jailer's fault. Yes, they pointed it out to the head jailer, but wouldn't it have been better just to stop it when it was happening? You know, and it doesn't make any sense. You know, and I see that's in here, but it doesn't say anything what happened to the person working. You know, and it's a question where I'm so torn about whether the arbitrator used all the findings that he was aware of. But I just wonder, was there other questions that should have been brought up that weren't?
Go ahead, Brad.
Shouldn't the supervisor be the one that issues the reprimand? And there was no reprimand because the supervisor didn't do it. So therefore, there's an egregious error in the supervisor's responsibility. That is a fireable offense under Wisconsin state law.
Alex, can you please explain what a right to work statement means?
There's been discussion about it already. It's at will. And there's a employment handbook that we have in Ashland County that provides grievance, and that's required by statute. We have to have a grievance procedure for someone that's fired. That remains. And the grievance procedure that we have in Ashland County is you can't be fired. And I'll read it exactly so I get it right. This is what the impartial hearing officer had to decide. That there has to be clean and convincing and satisfactory evidence that the county's decision to terminate has a rational basis. So that's the recourse that you have in the employment handbook here. Otherwise, it's at will employment, which typically doesn't require a reason at all.
George has his hand up.
Go ahead, George.
All right. You know, there's Bradley and Clarence over there, and they're right. It was an at-will contract. And if anybody been under a at-will contract? How many? Have you ever been terminated? So have I. I know, and I got terminated because of my age. Now, there's a federal law that says sex, age, color, skin, that can't be, but I was because of a at-will policy. Now,
I just
I
want
worked in a jail. How many of you has worked in a jail? I did. I worked there for 3 months, decided I wasn't going to be able to get along with not Miss Levaster, with one of the other lieutenants. Very unprofessional. And it was like they were picking on me because I was an
I'm just,
old man.
I'm going to interrupt really quick, Mr. Mick. I know we're all bringing our own experiences to the hearing today, but we got to be careful about adding new.
Well,
evidence that
I
wasn't
understand.
considered.
Well,
So
most
just-
of us might have had that experience. The thing of it is on page 3 of the rebuttal, it does say that after this meeting, it was concluded that the trust between Levasseur and Sheriff's Office could not be regained. That is so unprofessional, I can't hardly believe it was written. So when you got this kind of head button in beyond what was written, there's where some of the things, I think the county has been unprofessional. I think our sheriff has showed a little bit of unprofessionalism. So that's my thoughts.
Ron.
My confusion comes in watching the tapes. When I have one sheriff saying what a great job Lieutenant Levasseur did.
Yes.
I also have an issue with how long this went on. And I just feel like there are people above Miss Levasseur that should be held to account because nobody was fixing anything. And to put it on one person, I know we have to go someplace, but I think it's bigger than that. And as a county, we're going to have to look at who's going to run that jail next, because we need to straighten it out. So my remedy, I guess you could say, what I'm basing my determination on is from Mick Brennan, the sheriff at the time, upon his recommendation of what a great job Kim Levasseur did. And I really find it a little hinky that all of a sudden the sheriff is not there. And now we have a new sheriff that within a matter of days wants to fix this. Where the hell was he before?
Thank you, Ron.
John.
I see faults on both sides. So I think that the best thing to do is just to carry on. There's tons of people out there that are well qualified to do anything else there is to do. But to blame it on one person, it ain't gonna work. It has to be forgiven, get somebody new or whatever happens there, because it's gonna turn into a public battle.
Go ahead.
I wasn't in the rooms of the executive committee or, I didn't hear about any of this stuff really, especially until, after the fact.
Right.
It was hard reading it and I did understand,
a lot of the stuff Kim's going through is hard, and we as a county board, we have to make hard decisions. And I think unfortunately here, as a county, not as an individual, not as a person who knows Kim or doesn't know Kim or any of that, as a county board member, I have to make a decision, what he's already said 5 times, Mr. Moorbacher, is the grievance in error, and I can't find, I mean, there was a sexual assault that happened. That's big time. That goes to the top of the house right there. And so the previous sheriff isn't here anymore. He's gone. He's retired. So we have a new sheriff and he was voted in. I don't have any control over that. So I have to take what the new sheriff is saying, what Danny Grady's telling me, because again, I'm a county board rep and I'm not in the jail. I don't know those things. And so for me, I have to read this decision. And based on this decision, I have to say, I can't find a grievous error. And that's where I'll leave it.
I was going to say the same thing. As sympathetic as we can be as to what happened here, no one yet has told me where the hearing examiner made a grievous error in this opinion.
Yes, Kathy.
I'll tell you where the grievous error was. He was on the job for 2 weeks and he fired somebody that was 22-year employee.
The grievous,
let
we
me
need to
finish.
look at an error that that John Carlson made in this decision, not anything that happened previous to that. An error that in this decision that was made by the examiner.
If I could finish, I will tell you where that grievous error came. When somebody doesn't do their job right, you usually you'll say, Kim, here's what you have to do. You have to go to sensitivity training, or we got to help you improve on your job. She didn't get that. She got fired on January 30th or the 26th or the 19th, whatever you guys decide is the correct date. I've been on jobs and you don't fire unless it's absolutely the worst and they need to be fired that day. But you go and you provide training, and what else can you do? And what can the jail do to help with it? It's not on one person's shoulders. Thank you.
The grievous, Supervisor Campbell, the grievous error is in the hearing officer's determination that the statement of facts were sufficient to support the case. If the only statement of fact was, for instance, that the officer failed to take lunch breaks. Now, at will, the county could fire that person, but that's not sufficient. It would be a grievous error to consider that fact sufficient to support the determination. So not any set of facts is necessarily or could be considered sufficient, because if the officer had failed to go to bed at night, that would be a statement of fact, and it clearly would not be sufficient, and it would be an egregious error to terminate that person because they didn't go to bed at night. Thank you.
So I've heard abruptness as a reason. And I've heard that the facts don't support the conclusion. I think one way we could maybe focus this is just go through his findings and then determine if we agree with them. That was my attempt, with just highlighting some of the findings in there. One of the biggest findings, I think, was that a sexual assault occurred. And I heard from Ms. Franek that, I'm just taking notes as I go here, that we don't necessarily disagree with the findings, but that was just Ms. Franek. So I think we could maybe focus on that big fact that he found, that there was a sexual assault that occurred, and whether or not we agree with that or not.
I'm reading here that it was when it was determined that a sexual assault had actually occurred, that the inmates had already been separated into separate cell blocks. So it seems to me there had been a remedy. I don't know why the sexual assault accusation is such a big issue here, because it was in fact remedied before the accusations were brought against the officer.
So not a disagreement of the fact, just was there additional exhibits that talked about the remedy afterwards that the impartial hearing officer had?
It says in the summary that by the time the complaint about the sexual assault was recognized, that the two prisoners had already been separated. So there was no action necessary.
Okay.
That's what it says in his report.
I'd like to say something about that, George. If you read the entire proceedings,
This was not a one-time event. This isn't like this happened yesterday, so we'll report it. This was an ongoing thing that happened. I gotta tell you, first of all, I don't agree with at will. The whole system stinks. It does. It goes back to our previous administration, which destroyed everything we stand for in Wisconsin. I did talk to the sheriff about this. And when I heard that she had been fired, I guess I didn't agree with the process. There should have been disciplinary action taken, probably a demotion. What I have a problem with is, and I've been an employee advocate all my life. I have a problem with people being cut off from their health insurance. If you think that's not a big deal nowadays, just look at how much we pay for health insurance. One of the remedies, it's not a remedy that's going to fix this, but it's a remedy that will prevent this from happening again. I'm going to make a proposal to enter this in the employee's handbook. Pre-disciplinary hearing process offered before termination, which means one person can't drop somebody like that. And if that would have came before the executive committee, I think there probably would have been a different determination. Go ahead, Lauren.
I keep hearing two different things because there is a discussion about how short of a time it was from when the new sheriff had taken his position to the time he acted, and why didn't he do something before that? Before that, he wasn't the sheriff. He got in to his office and he took immediate action. But that was too quick for some people because he didn't do something before that. It wasn't his place to do that before he was sheriff. But we're going to be upset because he actually did act right away on the knowledge of these sexual assaults and not following the jail processes and such. So which do we want? He didn't do anything when it wasn't his job to do it, but when it was his job to do it, he handled it. You know, and in that, no, it wasn't what everybody thinks that he should have picked. But he picked something and he did it and he handled it right away.
Ron. Laura. Mr. Zupke was her boss. He could have done anything right then and there, brought up any disciplinary action, whatever. That's why I'm saying, why did it take so long? He was there. He was an actor in this whole deal. Why wasn't he moving? Yeah, we're trying to dump it on one person, but like I said, it's a lot bigger, and we're all not happy that the way the law states. And Mr. Ray's correct, but.
Go ahead, Liz.
You know, this sexual assault, it cannot be taken lightly or anything, but from reading the evidence and all that and stating that it was not a prosecutable, can't say that word, case, the DA would not accept that they were separated. The victim did not come forward right away. He always told the officers on duty that everything was okay. So how could somebody be reprimanded for something that did not or did occur.
In that police report we were given, as long as they were in the same block, the person being assaulted was fearful, so didn't really want to say much or report it. There's 3 incidents of sexual assault there, which is really 3 too many, but if one happens and it's not caught and noticed, that's 1 too many times that it's not caught and noticed. When I look at what the hearing officer wrote on page 7, Ashland County must only show that there is at least one rational basis. He lists a number. He says he's going to go through a number of things. Is there at least one rational basis? I would agree with him. There are, the sexual assault being the most important one. To me, not recognizing that the 67-page handbook is to be followed. If a person's been a correctional officer there for 20 years, and there's a copy of that handbook on each desk, clearly a person who's been working there as a correctional officer should know what's in that handbook. It's supposed to be reviewed and updated annually. When the inmates, when they're admitted to the jail, are read the rules, that 3-page summary there, that 3-page summary, which, the person had read, many, many times, makes that person well aware of what the rules are and the expectation for enforcement. I do agree with the sheriff in offering her a position back as a correctional officer, and I could still see that as something that could be considered after a thorough discussion of what happened and what needs to change. And I would certainly, Mr. Sindor, agree with you. There's a lot of things that need to change, but what's before us in at-will employment, is there at least one reason cited by the independent hearing officer for grounds for removing the person as the jail administrator? I would argue that there is. But at the same time, I'd like to see us come back and see if we can work things out so a person could finish their career there as a correction officer.
We've had some discussion about the sexual assault issues that were involved in this. And I'm reading from page 10 of the examiner's conclusions, where he discusses Detective Pierce's investigation. He watched several days of video surveillance video from the jail to see if the allegations could be substantiated. And then it says, assuming Detective Pierce's summary of the video is accurate, there are clear violations of the above rules. Ms. Lavasser testified that while she had not viewed the video, she had no reason to doubt Detective Pierce's report. My question is, why didn't she view the video? She was the department head. She should have viewed that video.
I'd like to say something here. One thing that really bothers me. In the jail, we have 24-hour surveillance. We have a tower up there where they have cameras on everything. It's a direct violation, first of all, to block what's going on in the cell with a bed sheet. The minute the sheet went up, it should have been reported and something should have been done about it. From what I understand, reading through this, saying that this is a daily occurrence. They want privacy in the jail, which is you forfeited your privacy. That's why you're there. I don't understand why this wasn't addressed. So there's more blame to go around than aiming at one person, but we're paying people to make sure in the jail and surveillance that everything is kosher. And in my estimation, that a warning signal should have went off immediately. They're up to something. And the authority should have been called in. They should have been, looked at and something done about it. But apparently the rules and regulations that operate a jail were not enforced or were ignored or something like that, because that's number one violation. You cannot take away the ability for the jail staff to monitor what the hell is going on in the jail cell. That's
That's just common sense. And the fact that nothing was done about that really bothers me. I agree with partially with what George said. Determination is unfortunate, and I said this from the onset when I first heard this. That somebody with that longevity should have been offered another position with the county so that they wouldn't totally lose their benefits. And I still feel that way. From what I understand, there was a discussion and more or less a shootout between Ms. Lavasser and Sheriff Zupke, and that pretty much is why he made his shoot from the hip decision. I think, in my estimation, what should be done, and this is just my estimation, that we should uphold these findings, uphold the termination, and let our petition for reinstatement in another position. I don't know anybody here that would not agree that she shouldn't be put out on the street, but there's not too many people agree that the job was being done the way it was supposed to be done. George.
Okay, two things. I'd like to point out there's a motion on the floor, first of all. And then secondly, with regard to my statement that the reason is abruptness, I refer to the examiner's analysis where it says Sheriff Zupke indicated that he did not terminate Ms. Lavasser on January 19th, but rather decided after he met with her on the 19th that she should be terminated. Sheriff Zupke, per Sheriff Zupke, he slept on it and then decided she should be terminated. That kind of abruptness invalidates consideration of the reasons that are purported to justify the termination.
Yes.
That's just insane.
Could you say the page number of that?
First paragraph on the date of termination A. Then I will read that. Sheriff Zupke indicated he did not terminate Ms. Lavasser on January 19th, but rather decided after he met with her on January 19th that she should be terminated. Per Sheriff Zupke, he slept on it and then decided she should be terminated, and a termination letter was issued within a week. That's just not appropriate. That's really unprofessional in my view.
Listen, now we've had a lot of important conversation here. I would like to take about a 10-minute recess. I know people probably need it. And then we'll reconvene.
Thank you, Dick.
Lori, can you please pause the video? We got to quit discussion. We're back in session. And we're back in session. We have to stop discussion. We have people who are leaving. All right, there's a motion on the table. I'm sorry, Mr. Bissay's not here. Can we wait a minute? It's his motion that's on the table, so we should wait for him to return.
Dick, can I say one thing while we wait for George?
Can you not say anything on the record yet?
Okay,
And wait for Mr. Bissay to get here.
okay. I'll try to be very brief.
But
That'd
Mr.
be a
Bissay
first.
deserves the benefit of hearing your statement. Every county board member deserves the benefit of hearing every statement so they can make the decision that they
Okay.
feel is best.
All right,
So please wait for Mr. Bissay.
I will.
Okay.
Thank you. One thing I'll say is thank you guys for repeating the question when you're asking for a vote. The yes vote means this and the no vote. That is very helpful for us who are hard of hearing.
Yeah, no, and I'll continue to do that so everybody understands exactly what yes means and what no means.
Thank
So
you.
they can make the vote that they feel is appropriate.
So what is the motion on the floor?
The determination was not rational because of so rushed. But I'll let Mr. Hussein.
Pardon?
Okay.
Okay, all right, Mr. Busse is back in. I'm sorry, Vic.
But that
Want to
wasn't,
recognize Kathy?
that wasn't the hearing examiner's decision.
Right. Oh, Kathy wants to talk.
Yes, Kathy.
Very quickly, this big discussion about the sexual assault that happened in the jail and that there's a video of it and why didn't Miss Lavasser do something with the video? There was no video. That's why she didn't have nothing to go on. There was no video. Ask her. Somebody ask her. She's here to testify.
She
No,
can't,
she
No, she not. She can't
All right,
testify.
let me reframe the question. There was no video in the jail of the
Okay, we
sexual
got it.
assault. End of conversation.
Bill.
No.
From reading the different things twice, I see that Ms. Lavasser had given out reprimands in the past, according to what's in the documents. Was anything I don't know if this is new evidence, but is a question, was anything given out on these sexual assaults? Was there any reprimands to employees where what is that new evidence? Shall I not be allowed to present that or ask?
if it's not something that Mr. Carlson considered, then it's not something we should consider.
Okay, so there's a motion on the floor. Mr. Busse, would you please repeat your motion?
After all this discussion, I'm not sure I'm going to have the wording exactly right. Does the secretary have the wording of that motion?
I have hearing officer decision was clearly erroneous and in error due to the abruptness of the employee's termination.
Okay, and to clarify, the abruptness has to do with the January 19th to January 19th, the next day abruptness of the decision.
Okay, and that was seconded by Ms. Shitty.
Could I add, just so I get this right in the written decision afterwards? It's clearly erroneous. The findings of fact differ in the sense that there's an additional finding that there was an abruptness in the firing, which led to a conclusion of law different than the impartial hearing officer finding that there was not a rational basis to terminate Ms. Lavasser because the decision was rushed. Is that accurate?
Could you repeat that, please?
So a determination that the impartial hearing officer's decision was clearly erroneous. There is
And egregious.
Okay, and egregious. The county, all facts otherwise are not disputed, but there's an additional finding that the decision was abrupt, that the impartial hearing officer didn't make. And that leads to a different conclusion in law than the impartial hearing officer, being that the county did not have a rational basis to terminate Ms. Lavasser because the decision was rushed. Is that accurate?
That's probably close enough.
That would cover everything but the remedy then in our written decision. Okay.
Pat?
For clarification, I would ask that we explain or understand what we mean by rushed, and in particular by who. The sheriff, how long had he known about these incidents that concerned him? When did he first know and learn of these? Had he talked to the county administrator? In other words, from the perspective of administration, how long had they considered it? What had they looked at, et cetera? So from their perspective, was it truly rushed, like, oh, we just saw this, well, let's do this today? Or had they known about this for a period of time? At some point as an employee, if your employer is going to take action, yeah, I'm sure it's, it feels sudden. But if the employer, I would ask what we know about when the administration, the sheriff first learned of things, and from their perspective, what homework had they done? What consideration had they given? And so from their perspective, was it rushed?
So I think Mr. Bousset is saying he's reviewed the record and he thinks there's a missing finding there. And so his motion is that based on everything that John Carlson had to look at, he has an additional finding that it was rushed. And so I think that could be argument that it's different. Yes. Okay.
On the floor.
I'll call the question.
Is there a second? Okay, there's a sufficient second. The question is called. You are voting on whether to stop debate on Mr. Bousset's motion. That the termination was rushed and therefore flawed. A yes vote means you're voting to stop debate. A no vote means you are going to wish to continue debate. Is a roll call requested?
Yes.
Okay, a roll call has been requested. Clerk Shitty, could you please read the roll?
Negro,
Yes.
Metzinger,
Yes.
Campbell,
Yes.
Ray,
Yes.
Kinney,
Yes.
Hufall,
Yes.
Frantic,
Yes.
Stark,
Yes.
Stendor,
Yes.
Berlin,
Yes.
Miranda,
Yes.
Hussein,
Yes.
Mika,
Yes.
Vitek,
Yes.
Huber,
Yes.
Shudi,
Yes.
Carl,
Yes.
Weiner,
Yes.
Murdig,
Yes.
Ellefson.
Yes.
McKenzie,
Abstain.
20 yes, pass.
The question has been called, therefore the vote is now on Mr. Bousset's amendment, motion. If a yes vote means you agree with Mr. Bousset's motion, a no vote means you disagree. Okay. Yeah, Mr. Bousset's motion was as a matter of law, the determination was rushed, was in error. The hearing officer was in error because the termination was rushed. Is that correct, sir? Was clear.
Impartial hearing officer's decision was clearly erroneous because there's a missing finding that the decision was rushed which led to a different conclusion of law than what the impartial hearing officer had, which was that the county did not have any rational basis to terminate Ms. Lavasser because the decision was rushed.
Okay, so a yes vote agrees with that motion, a no vote disagrees with that motion. And is there a roll call requested? A roll call has been requested. Clerk Shady, can you please read the roll?
Metzinger,
No.
Campbell,
No. Okay, there it's on. No.
Ray,
No.
Kinney,
No.
Hufall,
No.
Frantic,
What was? Okay, I can't remember now. Yes. Yes, it was rushed.
Stark,
Yes.
Stendor,
Yes.
Berlin,
Yes.
Miranda,
Yes.
Bousset,
Yes.
Mika,
Yes.
Vitek,
No.
Huber,
No.
Shudi,
Yes.
Carl,
No.
Weiner,
No.
Murdig,
No.
Ellefson,
No.
McKenzie,
Abstain.
Negro,
No.
eight yes, 10, or I'm sorry. 12 no.
The motion failed, 8-12 to 1.
But Brad,
I would like to make a motion to reconsider my original motion that to accept the hearing officer's statement in full.
I'll second that.
Okay, there's been a motion and a second. Is there any debate? Okay, hearing none, is a roll call requested.
Yes.
Clarify the motion, please. The
The-
vote,
The motion to reconsider accepting the hearing officer's decision in full.
as I understand it, the motion is whether or not we should reconsider
We-
the earlier vote.
Yeah,
right?
we're going to reconsider an earlier vote, correct?
Okay, so if we vote no against this on this vote, then it will not be reconsidered.
Correct. So a yes vote means you want to reconsider the earlier motion made by Mr. Ray to accept the hearing officer's decision in full. A no vote means you do not want to consider it. So,
Roll call, please.
and a roll call has been adequately requested. Chair, Clerk Sheedy, can you please read the roll?
Campbell,
Yes.
Ray,
Yes.
Kinney,
yes.
Hufall,
Yes.
Frantic,
No.
Stark,
No.
Stendor,
No.
Berlin,
No.
Miranda,
No.
Usse,
No.
Mika,
No.
Vitek,
Yes.
Huber,
Yes.
Shooty, Carl,
Yes.
Weiner, Murdig,
Yes.
Ellefson.
Yes.
Mackenzie,
Abstain.
Negro,
Yes.
Metzinger,
Yes.
twelve yes, 8 no.
The motion to reconsider has been approved, 12 yes, 8 no. So the motion on the table is the original motion made by Mr. Ray to accept the hearing officer's decision in full.
Roll call, please.
A roll call vote has been requested. Clerk Sheedy, can you please read the roll?
Can we hear the motion, please?
Yes, the motion, again, I just repeated it. The motion is to accept you're reconsidering the motion to accept the hearing officer's decision in full. A yes vote means you accept it. A no vote means you do not accept it.
Could I clarify or
Yes,
just
go-
ask a
please
question to clarify? So a yes vote is that we're finding the impartial hearing officer's decision is not clearly erroneous. There's no disagreement with findings of fact or conclusions of law, and that there was a rational basis on that issue of termination.
Yeah,
Okay.
they're voting to accept the hearing officer's decision.
Okay, thank you.
So that a yes vote means you accept it, a no vote means you don't. And there has been a roll call requested, so Clerk Sheedy, please call the roll.
Ray,
Yes.
Kinney,
Yes.
Hufall,
Yes.
Frantic,
No.
Stark,
No.
Stendor,
No.
Berlin,
No.
Miranda, Usse,
No.
Mika,
No.
Vitek,
Yes.
Huber,
Yes.
Shooty, Carl,
Yes.
Weiner, Murdig,
Yes.
Ellefson.
Yes.
Mackenzie,
Abstain.
Negro,
Yes.
Metzinger,
Yes.
Campbell,
Yes.
12 yes, 8 no, 1 abstain, pass.
The motion has been agreed to. The hearing officer's decision has been accepted in full by the county board. At this time, you can accept a motion to adjourn would be in order.
Aye.
Before we adjourn, do we not have to set the termination date?
We accepted it in
It's
full,
in that.
and so it's January 30th. And
What? I gotta see the big ones.
Need a motion? Do we have a motion to adjourn? All those in favor?
Aye.
Anyone opposed? Motion carries. Thank you.